Okay, Senator Hunt, you may open on LB 230.
Thank you, Chairman Lathrop and members of the committee. I'm Senator Megan Hunt, MEGANHUNT, and I represent District 8 in Midtown Omaha. This is LB 230. This is a bill very much in the same spirit of the last bill I introduced, and many of the arguments around it will be similar, though it applies to different arenas. Whereas LB 20, the bill we just spoke about, applies to employment, LB 230 takes it farther, and it applies to discrimination in housing and public spaces. LB 230 would update our laws regarding public accommodations in the Nebraska Fair Housing Act to ensure that Nebraskans, regardless of race, ethnicity, national origin, ancestry, religion, or sex, and now sexual orientation and gender identity, have a chance to fully participate in our communities here in Nebraska. To be clear, what we mean by public accommodations for Nebraska Revised Statute 20-133 are, quote, all places of businesses offering or holding out to the general public goods, services, privileges, facilities, advantages, and accommodations for the peace, comfort, health, welfare, and safety of the general public, and such public places providing food, shelter, recreation, and amusement, unquote. That would include but not be limited to hotels, motels, restaurants, anywhere with food service, gas stations, theaters, and any publicly owned facility. Under LB 230, it would be illegal to refuse service or otherwise discriminate against anyone in these places on the basis of their gender identity or sexual orientation, just as we currently protect other identity aspects like race or religion. With regard to the housing applications of this bill, the Nebraska Fair Housing Act, which is 20-301 to 344, generally applies to residential property owners, property managers, realtors, and multiple listing services. However, exemptions do exist for dwellings owned or operated by religious organizations and bona fide private clubs for non-commercial purposes, housing for older people, and owner-occupied private homes in which no more than 3 sleeping rooms are rented. So there are some limitations that there would be in this bill that are already in statute. Right now, there are hardworking Nebraskans who are gay and transgender that are unfairly treated by employers, evicted from their housing, and turned away from a business simply because of their gender identity or sexual orientation. 1 in 5 LGBTQ plus individuals report not using at least one type of public accommodation in the last year due to fear that they would be mistreated or abused as a trans person. A third of trans people report experiencing at least one type of mistreatment in a place of public accommodation, and a third also report being denied equal treatment or service, being verbally harassed or physically attacked in retail stores, hotels, restaurants, or theaters. These kinds of discrimination are disproportionately directed toward trans people and LGBTQ plus people that have disabilities. This discrimination not only affects LGBTQ individuals, but their families as well. Nebraska is home to an estimated 67,000 of these residents, and of those over the age of 25, 32% are raising children, including me right here. No parent or child should be homeless just because of who they are or who their parents are. Gay and transgender people and their families deserve clear, consistent protections against discrimination under Nebraska law. There are protections that are present for LGBTQ individuals in 22 other states, including our regional neighbors of Iowa, Colorado, Illinois, Minnesota, Utah, and Wisconsin. In states with LGBTQ anti-discrimination laws, we see a significant decrease in bullying, cyberbullying, and school performance, an increase in school performance. Employment, housing, and public accommodation laws are associated with a 30% decrease in bullying when compared to students in states without anti-discrimination laws. Additionally, they have seen a decrease of 25 to 40% of cyberbullying instances. LGBTQ students have reported a grade point average drop of 0.25 points, a difference that is narrowed by 33% in states with non-discrimination laws. Marna Munn from the NEOC is here to testify today, I believe, on this bill, and I can let her speak to some things in more detail. But for the same reason described in my testimony on the last bill, it's important for the Commission to have these gender identity and sexual orientation bases be clearly and explicitly included in the Nebraska Fair Housing Act and in our public accommodation laws. As I mentioned in my last bill opening, I recently conducted an informal survey of Nebraskans, and they overwhelmingly stated that young people want to live in places where they are accepted and their culture reflects their values. 73% of Nebraskans support policies to prevent LGBTQ plus discrimination in housing and public accommodations. This support not only keeps residents here, but encourages visitors and LGBTQ organizations to come and expand into the community, thus helping our economy. But of course, regardless of your position on this bill, you already know this. Providing a commercial service doesn't mean that a business owner endorses or agrees with everything their customers believe. It simply means that the business owners are providing goods or services to the public and that they must be open on the same terms to everyone. No one should be denied the ability to get a sandwich, a haircut, or vehicle because of their sexual orientation or gender identity. Please vote yes on this bill to protect our residents from eviction, rental application denial, or denial from a business or public facility simply for being gay or transgender. Thank you.
Thank you, Senator Hunt. Any questions for the Senator? I see none.
Thank you.
I'm confident you will be around.
I will.
Okay, good.
It's my favorite place.
I know. This afternoon it is for sure. Thank you. We will take proponent testimony. Anyone here to testify in support of the bill?
I'm sure I got the right bill here. This is 230, right?
This is 2:30. You're in the right place. Welcome.
Thank you. Thank you, Senator, for stopping me on that last one.
Let's start with your name.
Okay, it's Judy King, Judyking. And I am a proponent of LB230, and would you please make this part of the record? I wasn't quite sure what to write down for this. So I thought, well, I'll look up the testimony from the Catholic Conference for LB229 on February 24th because I wanted to see how they thought about gender identity. So I could counter their ideas, but to my surprise, this is what they said. The Catholic faith recognizes the supreme dignity of every person as it is made in the image and the likeness of God. The only appropriate response to this reality is charity. For this reason, the Catholic faith also recognizes that no one, including those who are experiencing, experiencing same-sex attraction or questions about their own gender identity should be subject to violence or unjust discrimination. Everyone should be treated with the respect and dignity, and any act that violates charity and justice, including criminal acts, should be categorically condemned. And I was surprised. They could have left it right there. I couldn't have said it any better. But they could have left it right there. And then they continued to contradict the previous comment by saying LB 229 seeks to import the definition of gender identity that undermines the biological and given reality of sexual difference. It is one thing to be understanding of human weakness and the complexities of life, and another to accept ideologies that attempt to sunder what inseparable aspects of reality. The aspect of reality is not mere theological rumination for people of faith, but a basic building block of any flourishing society, and any policy that undermines it should be assiduously resisted. That's when they contradicted it. And to me, the words gender identity are a description of a human being. The bill will stop the discrimination against a human. But to the Catholic Church, it means much more. It means the ruination of a flourishing society and should be resisted. Actually, my God expressed to me that in a flourishing society, people need to educate themselves. And a group of pious hypocrites that harbor pedophiles should not be our moral compass and should not have any say in the laws that are heard in Nebraska legislature or anywhere. My God has also told me that there are several ways that you can get to heaven, and it's not necessarily by the Catholic ideology. But I do appreciate their first comment on that, and that's all I have.
Okay, any questions for Ms. King? I see none. Thank you
Thanks.
for your testimony. Anyone else here to speak as a proponent? Anyone else here as a proponent? Welcome back.
Thank you. It's been a long time. My name is Sarah Rips, S-A-R-A, last name R-I-P-S. I just want to thank Chairman Lathrop and the members of the committee, as well as Senator Hunt, for bringing this bill. I'm here today in support of LB230, which updates and harmonizes our existing civil rights laws to align with recent Supreme Court decisions and the NEOC's application thereof. It is common practice in countless contexts that when federal law changes due to legislation or court decision, that state and local governments then update and harmonize their laws. This happens frequently and is honestly just a good governance practice. So this legislature handles that regularly. Not this committee, but this legislature, tax, agriculture, transportation, public benefits. It is important that we send a clear message that Nebraska's motto of equality before the law applies to every Nebraskan. It is important to send a clear message that Nebraska is open for business. It is important to send a message that Nebraska is welcoming. I'm not listing mere platitudes. These are literally the factors for things like brain drain, business and academic retention and recruitment, things for metrics on things like Zillow, and overall economic development rankings. Senator Hunt's bill aligns with the beliefs of the majority of Nebraskans. In polling conducted by UNL in 2018, Nebraskans across the state political spectrum and religiosity support LGBTQ non-discrimination. Statewide, 75% of Nebraskans support having protections for gay, lesbian, bisexual, and transgender people in jobs, public accommodations, and housings. A 2019 poll from an independent organization, PRRI, found that 73% of Nebraskans favored these laws. It is important to update our civil rights laws for legal, policy, and practical reasons. Most Nebraskans prefer filing these types of cases in venues that are closer to home, in state or local courts. It also saves time and money. Rather than having to deal with this in the form of Supreme Court lawsuits, you can amend the law now and save taxpayers money. Despite all of the progress that LGBT people have faced and have experienced in the last 10 years, we have a long way to go. And as an LGBTQ Nebraskan, I know personally we have a long way to go, but I know we can get there, and I am absolutely excited for the committee to help us get there. Thank you.
Very well. Thank you for your testimony.
Thank you.
Good afternoon. Welcome.
Good afternoon, Chairman and Senators. Thank you for having me today. My name is Kayla Meyer, K-A-Y-L-A-M-E-Y-E-R, and I'm currently the coordinator for the Lincoln Young Professionals Group. You heard from Paige earlier today on 120, and I'm here to support LB230 on behalf of YPG. As you heard from her, we are the largest YP group in the state. We are one of the top 10 largest in the country, with over 2,000 members here in Lincoln and Lancaster County. Lincoln YPG Leadership Council supports this issue unanimously time and time again. As Paige said earlier, we have been at the forefront of this issue for over 7 years. We firmly believe that all people should be treated fairly and equally, Discrimination is already against the law when it comes to factors as race, color, religion, sex, national origin. We need your help to, excuse me, even that playing field and protect our fellow LGBTQ Nebraskans. Just yesterday, the United States House of Representatives passed the Equality Act, which would expand protections for LGBTQ people by prohibiting discrimination based on gender identity and sexual orientation. President Biden said full equality has been denied to LGBTQ plus Americans and their families for far too long. This can clearly be said for the LGBTQ community in Nebraska as well. Whether the Equality Act will make it into law is yet to be determined, but as a state, we have the opportunity to step up and act now to ensure that these protections are provided for our citizens. It is not just the LGBTQ community who is attuned to this issue. Straight, Gen Z, and millennial employees who will soon make up the majority of the workplace also care deeply about this inclusion and are more likely to advocate for it than previous generations. Our society is becoming more diverse. It's steadily becoming more inclusive and more accepting. This is a positive development and a strength that our state should cultivate and encourage, not disregard. Attraction and retainment of young talent is crucial to Nebraska's economic future. When we look at recruitment, LGBTQ individuals make up about 5% of this workforce. But as I mentioned, that's not the community, that is not just the community that's paying attention to this issue. Allies, friends, families, those that want to live in a welcoming environment are paying attention too. You can go to Zillow right now and scroll down and find out that we are not a welcoming community in 2 clicks. People are paying attention to that. And we need to pass LB230 to make sure that Nebraska remains attractive and competitive.
Very good. Thank you for your testimony. I do not see any questions at this point, but thanks for being here. Other proponent testimony. Anyone else here to speak in favor of the bill? Okay, we're going to take opponent testimony, and before anybody jumps up, I would like to have those who did not have an opportunity to speak on the last bill and oppose this bill to come forward first, so that we have an opportunity to share the opportunity. If that makes sense.
What is it? 230.
Welcome back.
Hello. My name is Gwen Easter, Gweneaster. I did not prepare to speak at these 2 hearings. But sitting here, listening to all this going on, first of all, I want to say that I'm a person that I don't believe that people should be discriminating on the job, a housing. I offer a housing program service in North Omaha, and I've done that for 20 years, helping families find homes, advocating for them to get a utilities assistance and things like that. So I don't believe that people should be discriminated. If they're able to do their jobs, then that's what they should be, hired for, to do their jobs. Not if they are gay or straight or married or single. And, some of the things that was said here today, I feel like it is being put out there, like, people who have a different opinion about the lesbian, gay, LBQ or gender, that we are homophobic, that we are mean, nasty. I'm a Christian, and I'm not ashamed, and will never be ashamed to say that. I love God and I love people, and what God told me to do is to love people, respect people. We have to love people. So loving someone doesn't mean that you agree with everything. Okay? So I'm not a gay hater. I don't hate gays. I got gay people in my family. But that does not mean that I have to agree with everything. Now, am I going to discriminate against somebody? No, I'm not. But y'all don't have a right. This gay and lesbian, this whole thing is being pushed up on people that may not necessarily agree, and that's okay. They don't have to agree. We don't have to agree with somebody else's choice. And yes, it is to me a choice. It's a choice because I see other people who I know who used to be and is not now. You know, and yes, it angers me because when I see somebody sit up here and say, you know, because I love Jesus, that I hate somebody, or you know, I'm discriminating against them because I don't agree. I have a right to speak how I want, and I tell you this, you know, all this they language and all this stuff, it is a violation to other people who don't agree. You know, you're pushing this or in our schools. They're pushing this on TV. They're doing all of this. Oh, but if other people speak out and say that they're against something or don't agree, we're hating people. No, I don't hate nobody. But I refuse to allow people to push what their lifestyle, their choices are up on my lifestyle. You don't have to agree with me. You know what I mean? I'm not going to hate you. I'm not going to hate you. I love people, and I don't care what people think or say. You know, you still do not have a right to push your lifestyle up on other people in the manner that is being done in our schools, everywhere we turn around. Okay. You know, everybody don't agree, and that should be okay. I still say don't be firing people if they are living that lifestyle. That is their choice. Though that is their choice, and nobody should do that. But don't infringe upon my right to think how I feel and how God gave it to me. He gave me to love people. I don't have to agree with your lifestyle. And that's all I have to say.
Okay, I don't see any questions. Thank you, Ms. Easter. Anyone else here to testify as an opponent?
Afternoon.
Yes,
Thank
it
you for
is.
the opportunity to come before you, Senator Lathrop, and members of the committee once again. I'm Karen Bolling, KarenBowling, and I serve as the Executive Director at Nebraska Family and testify on behalf of them today. Across the country, government officials and others are using state and local sexual orientation and gender identity as protected classifications to threaten Americans' constitutionally protected freedoms and infringe upon free speech, conscience, and what I really want to focus on now is bodily privacy. Who are the victims of SOGI laws that violate bodily privacy and safety in a public accommodations? For example, the Downtown Hope Center, a women's homeless shelter that provides a safe place for women who have suffered rape, physical abuse, and domestic violence, was investigated by the city officials and actually taken to the court of law in Anchorage, Alaska, who claimed that the city's SOGI public accommodations and housing require the shelter to house biological men alongside women in overnight sleeping facilities. Pasha Thomas, a 5-year-old daughter, was sexually assaulted in her school restroom by a male classmate who identified as gender fluid and allowed to use the female restroom under the Decatur, Georgia School District's SOGI policy. During her junior year at Boyertown Area Senior High School in Pennsylvania, Alexis Lightcap was both scared and embarrassed when she walked into the girls' restroom at school and found a boy inside that proceeded to follow her into the locker room. Recently, I received a call from a Lincoln businesswoman who experienced the tragedy of sexual molestation by a family member growing up. As she travels to conduct business, she communicated to me in several airports where SOGI public accommodations exist, she is triggered when a biological male enters a woman's bathroom. She doesn't look at this as a political, she doesn't look at it as a hateful, but she has to make a decision. Is this safe for her because of her personal experience? In order to continue to make a living, she is re-engaged in trauma-informed counseling to develop strategies so she can continue to do her job and make a living. Government officials have also used SOGI laws to force churches and faith-based organizations to violate their sincerely held beliefs. Iowa and Massachusetts officials interpreted their statewide SOGIs to apply to churches, meaning they could be prosecuted for operating consistently with their church's faith statements and ensure visitors use sex-specific restrooms and changing areas. These are real-world implications. Bodily privacy and dignity must be protected. We ask that the Judiciary Committee not advance LB 230 to general file. Thank you for your time.
Okay.
Take your
I
questions.
don't see any questions, Ms. Bowling, but thanks for being here.
Thank you, Senator.
Always. Next testify.
Welcome back, Mr. Chairman. Thank you. My name is Matt Sharp, M-A-T-T-S-H-A-R-P, and I'm Senior Counsel with Alliance Defending Freedom. Our firm has had the pleasure to represent incredibly talented artists that have experienced firsthand the consequences of law like LB 230. We represent Baronelle Stutzman. She's the florist in Washington State, had a longtime gay customer. She knew he was gay, loved him, loved the creative challenges that they would come up with when she was doing floral arrangements for him, considered him a close friend. And one day after years of service, he asked her to do the floral arrangements for his same-sex ceremony. And she politely declined, explained why that would violate her faith. The next thing you know, Baronelle was dragged into court, sued both personally and corporately, such that everything she owns is now on the line. She's been battling that case for years, had gone up to the Supreme Court, back down to the state Supreme Court, and is now waiting at the Supreme Court. We also represent Jack Phillips, who Karen Bowling had mentioned earlier, and who you all had the opportunity to meet 4 years ago. He's the Colorado cake artist that similarly serves everyone, but declined to create a same-sex wedding cake and was sued. And even after winning at the Supreme Court, has now been sued twice again and is still in litigation over one of these laws. With both Jack and Baronelle, they gladly serve everyone. And what they object to is the government being able to force them to create messages, expression that violates their beliefs. But that is, again, what laws like LB 230 unfortunately do. They enable this ongoing persecution against people like Jack and Baronelle and other creative professionals. And I want to contrast that treatment of Baronelle and Jack with a story from just last year of a Detroit cake artist. Her name was April Anderson. She's very talented. She's also a lesbian. And she was asked to create a custom cake with a religious message criticizing same-sex marriage. She declined because she found it objectionable. And the customer accused her of religious discrimination. But while Baronelle and Jack have been scorned, April was celebrated by national news outlets. In fact, the ACLU of Michigan stood by her, stating, "When you are asked to do a particular message, you might be crossing the line of what could be compelled speech, especially if it's offensive." And I agree. That same principle should apply to Jack and Baronelle and to creative professionals here in Nebraska, that the Constitution doesn't play favorites when it comes to speech. Rather, it protects the freedom of all Americans to express or not express their deepest beliefs, no matter whether others in the community or in the halls of government disagree with that expression. Tolerance and respect for good faith differences of opinion are essential in a pluralistic society like ours. They enable us to peacefully coexist with one another. But laws like LB 230 will result in kind-hearted Nebraskans being dragged into court and punished by the government for peacefully seeking to live and work consistent with their beliefs. Thank you for your time, and be happy to answer any questions.
Thank you, Mr. Sharp. Senator McKinney.
Thank you. I do believe you have the right to believe what you want and think what you want and say what you want, but I also believe that you also have to take on the consequences of your beliefs as well. Dang, I forgot my question. But I guess my question is, do you, dang, I forgot my question saying that, but I'll come back to you if somebody else got a question.
Thank you, Senator.
Yeah.
Okay, I don't see any other questions. Thank you, Mr. Sharp.
Thank you, Mr. Chairman.
Next opponent. Wendy.
Welcome, Mr. Venzer.
Thank you. Good afternoon. I don't know if your vice chair is that the role you play. So, and members of the Judiciary Committee, my name is Tom Venzer, Tomvnzor. I'm the executive director of the Nebraska Catholic Conference. I've got some testimony going around to you, but I'm not really going to read it word for word. I might talk about a couple things that are in it, just so you know, so you're not trying to follow along necessarily. If you go down to that second to last paragraph, I have a piece in there about LB230, kind of like LB120. It has an application to the local and statewide public accommodations law. And as I raised earlier in that testimony, in 2019, a 3-judge panel, the 8th Circuit Court of Appeals, recognized in part of its sort of holding or its rationale that when laws seek to regulate speech itself as a public accommodation, it has gone too far and its interests must give way to the demands of the First Amendment. The point there being is in that case in Telescope Media Group versus Lucero, which I think is actually also a Alliance Defending Freedom case. In that case, basically what you had was, I can't remember if it was a local or a statewide, basically public accommodations law. In there you had Telescope Media Group, which did sort of videography work, and essentially they were asked to do a same-sex wedding ceremony. They declined to do that, and again, they were brought in. They had a claim brought against them for violation of public accommodations law. And the 8th Circuit ultimately said they sought a preliminary injunction against that. It wasn't dealt with. Then the 8th Circuit Court of Appeals basically remanded back down to the lower court to say that you need to revisit the preliminary injunction issue based on the fact that this public accommodations law, as applied to the area of speech, raises fundamental First Amendment free speech problems because it's forcing the hand of Telescope Media Group to engage in speech that it does not agree with, and in terms of basically viewpoint content-based discrimination. So I wanted to, that's one angle here of one of the aspects of the implications of a law that deals with public accommodations law. The second thing I wanted to mention, this bill also deals with statewide housing issues. In there, I think what's notable is that there's, we've talked again what's going on in other states, what have we seen. I know that there's another case that has a petition for writ of cert at the U.S. Supreme Court, Aloha Bed and Breakfast versus Diane Cervelli, which is in my footnote 4. And there you've got a situation of a woman basically running a B&B out of her home, and again had a same-sex couple come to her to want to utilize her B&B. She was a Christian who had a particular belief on marriage, that it's between one man and one woman, and basically a discrimination claim was filed against her in the entity that she was, the bed and breakfast that she was basically running. So again, these laws have an impact on somebody who has a differing belief system on the nature of marriage and human sexuality. And I will get to one point that I think Senator McKinney just raised about, you can hold your view, but there's consequences for that. And I think, obviously, I think we would all know that there's consequences for the beliefs that we have. And this is where I would just, one last thought, if I could wrap it up. Thank you. To go back to Justice Anthony Kennedy, like I did earlier, where he said in the Obergefell versus Hodges case that those who hold the traditional views on marriage and human sexuality have held these in good faith by reasonable and sincere people here and throughout the world. So the question ultimately is, if people hold sincere and reasonable beliefs on marriage and human sexuality, do we basically want to bring down the heavy hand of government when they hold on to that sincerely held religious or moral view? So with that, I'll take any questions. Thanks for the extra
We do
second.
have one from Senator Pansing Brooks.
Yeah, thank you.
I'll read it to you, Mr. Venzer. When people used to discriminate against Catholics and other religious groups, the religious groups rose up and demanded protections against discrimination, even though people from other religions did not agree with the Catholics and other faiths. When is it okay to use your protections as a sword now that you have the shield of protection against discrimination?
Yeah, thank you for that question, Senator Pansing Brooks. So again, the thing here is we're not talking about engaging in some sort of unjust forms of discrimination. What we're talking about is the problems with these proposals, LB120, LB230, is that they're not treating those who hold a differing view on marriage and human sexuality. Again, to go back to Anthony Kennedy, they're people who in good faith, they're people who've held these in good faith, and they're reasonable and sincere people here and throughout the world. Okay, that's what he said in Obergefell versus Hodges when he crafted the right to same-sex marriage. The idea there is, in this law, is how are we going to treat those people who have differing, reasonable views on marriage and human sexuality? Are we basically going to go after them with the force of governmental power, or are we going to recognize that they have differing and competing views on this issue, and that's kind of the situation we're going to be in. So I don't think we're here to basically, say we're here to defend our own special protections or what we were once protected so nobody else should be protected. And we've had this discussion before too. If there can be a place where there's a real showing of unjust, ongoing, systemic, widespread discrimination, and if we can identify that and really get to that issue without having all these other repercussions and intended and unintended consequences on people of faith, on other people who hold moral values, on marriage or human sexuality, and they're not going to be dealt with in an unjust manner as well. I mean, we can have that discussion, but the problem with these bills is that while they attempt to deal with some unjust discrimination, it's doing a lot of other things also that are problematic. And again, we've seen that across the country. If we want to go into the housing and that kind of area and talking about the effect on places of faith, like in the adoption foster care context, what we've seen there, right, is Catholic Charities of Washington, D.C., Catholic Charities of Boston, Massachusetts, Catholic Charities in Illinois, in San Francisco. We're seeing a case right now in front of the U.S. Supreme Court, Fulton versus City of Philadelphia, where essentially you've got questions of non-discrimination laws coming up against foster care and adoption providers. And all of the ones that I listed before the City of Philadelphia case, all of those entities had to shut down their foster care adoption agencies because the city was essentially requiring them that if you don't serve the LGBT community, in other words, if you want to hold your sincerely held religious belief on marriage and human sexuality, that's nice, but you have no place in foster care and adoption services, so you're out of the industry.
I think we get your point.
Yep.
And I want to make sure there's time for other
you bet.
opponents.
Yeah, thank you.
Mr. Benson,
There's a ramble.
unless there's other questions. Senator McKinney.
Thank you. Mr. Venzer, I got a question.
Mm-hmm.
How can someone peacefully coexist in a society when there are individuals that don't want to recognize who an individual is as far as sexual identity or gender? How can you peacefully coexist? How can you be comfortable in society when there are people that believe that you shouldn't be somewhere, you should be denied housing because you choose to identify as something that they don't believe in?
Yeah, thank you for that question. I mean, I think that's a question on both sides of on both sides of the issue here. How can a society, and a pluralistic society, a society that has a diversity of different people who come from different backgrounds, faith backgrounds, understanding of their human sexuality, et cetera, how can we create a situation where they can, sort of, to use your language, peacefully coexist? Because again, on the other side of this, you have people with sincerely held religious or moral beliefs. They don't even have to be religious beliefs about what marriage is and what human sexuality is, whether marriage is between one man and one woman or that we are created male and female. The question then becomes, how can we also basically recognize that fact that you have people who hold that view, that they do want to participate in the economic life, they do want to participate in the community social services, they do want to participate in the housing industry, et cetera, but if they hold that view, they're going to be sort of coerced or disciplined by the state because of their view on marriage and human sexuality.
I just think there's a fine line to that. There were people earlier saying that if one of Senator Hunt's bills was passed, that we're forcing government upon people. And I think in the same vein, you could say individuals are using their religious beliefs to discriminate against people, and that isn't fair either. And I just think, you can believe what you believe, but you don't have to hate somebody because they don't identify with something you don't identify with. I'm against oppression, discrimination in all forms, especially as a black man in this country. And I just think if somebody's living their life, let them live their life. Why do we have to have things in place to say you can't be something or do something or live somewhere? Let people be. Like, what is the purpose of saying this is bad, this is horrible? Like, just let people be. If they're not punching you in the face or doing something wild, why do we constantly have people coming in here being against this type of legislation? Why can't we just function as humans and be humans?
Well, so I guess that's what I'm getting at, is that laws like this have had intended and unintended consequences on people who hold a particular view on marriage and human sexuality. So the idea that we just want to let people be and do their thing and just let them exist and whatnot. The issue here is that legislative proposals like the one we're talking about actually do have a serious adverse consequence on actual people who hold, again, views on marriage that, again, Justice Anthony Kennedy said that these are held by reasonable, insincere people, that we're not talking about these are hateful views. We're not talking about people who just have, deep animus and hatred in their heart. Now, it could be that some people maybe also hold those views in that area, and that's a deep problem with their own heart. We're not coming here to talk about people being able to just hate on people. And I don't think we should basically make synonymous religion in hatred. I think there's sort of a fallacy underlying that sort of concept or that equivocation. And I don't think we should go that route, because that's not what we're talking about. What I'm talking about here today is the impact that this has on people of faith who hold a particular view on marriage and human sexuality. I think that's what we're talking about at the end of the day. This legislation has real impact on real people as well. So if we want to talk about the existence of unjust discrimination against those who are in the LGBT community, and do that in a way that it's not going to be harming also other people who hold sincere and religious and moral beliefs on marriage and human sexuality that have been held by all sorts of people for thousands of years, we can have that discussion, but these bills aren't striking that balance by any stretch of the imagination.
Thank you.
Thank you.
Thanks, Mr. Vinzer. Thank
Appreciate
you.
it. Okay, thank you.
Yeah, we will take the next opponent. Seeing none, we will take neutral testimony.
Good afternoon again, Chairman Lathrop and
Welcome
members.
back.
Thank you, to the Judiciary Committee. Again, my name is Marna Munn, M-A-R-N-A-M-U-N-N, and I'm an attorney and the Executive Director of the Nebraska Equal Opportunity Commission. And I'm coming to testify on LB230 in a neutral capacity. I'm going to try to surprise you all and not gain steam like a freight train and remain calm here and just make a couple of points and then be available for questions. First, you may wonder why I'm in a neutral capacity on this bill as opposed to the last bill. And just in the interest of the discussion regarding neutrality, if this were simply the housing arena, which would be the equivalent of Title VIII in the federal law, then I would be testifying as a proponent to it as well for all the same reasons as I did for LB 120. There are a couple of nuances to the law because Bostock applied specifically to Title VII, but I was on the record in the news and the commission backed this last August that given that Bostock applied to a section of the civil rights legislation that Title VIII is predicated upon and often intertwined with, we felt we were on solid legal ground, spreading essentially Bostock to Title VIII and then to the State Fair Housing Act That has borne out in that the president signed an executive order saying as much, and 2 weeks ago, HUD, Housing and Urban Development, our federal partner in housing, issued new guidance and rules consistent with that. So that's the solid ground with regard to the housing piece. I'm testifying in a neutral capacity because there wasn't a check mark for it's complicated. And when, for the portion that relates to public accommodation, I think you all know, but for the benefit of the record, public accommodation falls under Title II of the Civil Rights legislation on the Civil Rights Act. It does not contain the word sex on the federal level. So where sex appears in public accommodation laws, it's been added there by states, and over 40 some states in the country added the word sex to their own state level public accommodation laws. We also have no federal partner to whom we look for guidance on Title II issues with regard to public accommodation. But again, even if we did, they wouldn't have anything to say on sex as it's not in the law. The Equality Act, which passed the House yesterday, was raised and should be noted for the purposes of the hearing because it does in fact would actually add sex and sexual orientation and gender identity explicitly to the federal public accommodations law, and that might put us in a different position. The commission itself, while backing the housing interpretation, decided that we should do more research and look into other states, and there are at least 17, and then municipalities, and there are over 200, which have sexual orientation and gender identity protections for public accommodations. And we're still in the process of doing our research, and because the commission has not taken a position post-Bostock on public accommodation, I can't in good faith come and testify in anything other than a neutral capacity. I would say, I think the most important thing to note is Obergefell gets raised and Masterpiece Cake get raised. And
Wait a minute, can you say that again? Because I couldn't.
I can. Obergefell, the federal case for same-sex marriage, and Masterpiece Cake, the case about religion and the cake out of Colorado, are raised, and I'm going to invoke them right now because I think they're a good illustration of how we have to come to a balancing act. One says that religion isn't more important than the protection of sex in that context for marriage. Masterpiece Cake says exactly the same thing in the reverse, and that's the balance, and our agency would have to strike that balance, as all agencies looking at public accommodation issues would have to do. So I wanted to note that for public accommodation because so often it comes down to religion versus sexual orientation and gender identity, and how can we ever find a balance? Well, all of the court cases listed to you should suggest that there's a mechanism out there that allows us to figure out that balance. Anytime you have a new law that intersects with something else from a different law, you always have to go through that process. And it sounds like, based on the court cases and the ones I'm aware of, that process is working just as it should in a country of laws. And so I just wanted to go on the record and say we don't have any qualms about figuring that out, because I think there's guidance out there and the law has been contoured in other places prior to coming here. So I just thought it was important to bring that to the table and explain that I think that we can handle it. And then the restroom issue always gets raised as well. Again, 17 states have it in place. There are anecdotal issues. There were anecdotes brought earlier, but I just want to say, if you think about what was brought, some of those wouldn't fall under this law in the first place. And again, it was a few examples, and it's unfortunate, but I'm not sure that, as far as I can tell, there are not high levels of statistics supporting that there are issues when these kinds of laws of that nature, when these laws go into effect. And so I just wanted to bring that clarity, and while we are neutral and have not decided that Bostock automatically applies to public accommodations, I just wanted to address those issues and answer any other questions you might have that I could address, that you think I could address for you.
Okay. Any questions? I don't see any. I know that you come down every time we have a discrimination bill, here or in business and labor. I appreciate the information you give the legislature, specifically this committee, and business and labor on these issues. Sometimes, as you say, it's striking a balance between competing interests, but we always learn something when you're here, and it's helpful.
I will, I'm not going to prolong it. I would note that in each of the laws that have been addressed today, there are already on the state level exemptions relating to religion and religious-based organizations already in our public accommodation law, in our housing law, and in our employment law.
Where are those found?
I will send you the list across
Please.
three. The one in my mind is 2137 for public accommodation, but I can't.
Why don't you share those with the committee if you wouldn't mind?
Absolutely will.
And I think that would be helpful.
They may not be as robust as what was being addressed today, but I wanted you to understand that they exist in each of the law on the state level already, at least some, in some form or fashion.
Okay, thank you. I appreciate it. Any other neutral testimony? Seeing none, Senator Hunt, you may close on LB 230. We do have 53 letters, position letters. 21 of those are proponents, 32 are opponents, and we also have written testimony, which I'll next read into the record. A proponent, Robert Sanford, with the Nebraska Coalition to End Sexual and Domestic Violence. Also a proponent, Anna Eichholt, with the YWCA. Also Abby Swatsworth with Out Nebraska is a proponent. Also a proponent, Kelly Waldron with Women's Fund of Omaha. And finally, Justin Brady, representing Nebraska Realtors Association, is a proponent of LB 230. That was written testimony received this morning. And with that, Senator Hunt, you may close.
Thank you, Chairman Lathrop and members of the committee. Everything I said in my opening on this bill and all the discussion that we had, the things I said in my opening and closing on the previous bill stand. I appreciate Ms. Munn's point about the religious exemptions in state statute already. That's totally true. I don't, if people would like to clarify that in this bill, we can do it, but I don't like to do redundant things in statute. You know, if it's already included in our law, I don't think that we should clarify it because that would be redundant. On this bill as well, this public accommodations bill, I'm proud to have the support of Mayor Stothert in the city of Omaha and Mayor Gaylor Baird in the city of Lincoln. These are cities run by amazing women who see the future of our state and what kind of culture we have to invest in creating if we want to keep people here in Nebraska and be the kind of place that people can see themselves living. People don't have to agree. Nothing in this bill says that people have to agree, but people cannot discriminate. If people would like to run a business or a hotel or a public business, if they want to employ people, state government, all of these different political subdivisions, they cannot discriminate. And we don't accept discrimination on the basis of sex or on the basis of race or national origin or religion, ability. And we have these protections in place because we believe in the dignity of human beings. And LGBTQ people are in that same basket. And it doesn't matter what your sincerely held beliefs are. If your beliefs are discriminatory, you need to keep them in your head where they belong and not put them on people who want to rent a hotel room or get a job or buy a birthday cake, whatever. It doesn't go both ways with that. And as government, we have to err on the side of non-discrimination. We can't police what's in people's heads, but no one's trying to do that. I think that in order for people to live their best life and to have the high quality of life that we want people to have in Nebraska, we just need folks to be able to mind their own business. And that's all LGBTQ people are asking to be able to do, is just mind our business, go to work, buy a birthday cake, and not be worried about facing discrimination or violence. Thank you.
Okay. I do not see any questions in follow-up, so that will close our hearing on LB 230.